welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we say every time, this program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether or not you need to work with a lawyer. If you do decide to seek outside professional counsel, we hope that you will be better prepared. That's our goal, of course. The idea is that either way, you'll save time, money, and hopefully achieve the best possible results. We welcome and thank David Bazar once again. David, from the Bazar & Associates law firm in East Providence. They continue to help us with insights and information on the various issues that we tackle. Today, more of the questions that you ask every day. Recently, we've had very good, strong feedback and more questions that our viewers would like to have answered, so our legal eagle here is going to tackle some of them. Okay. So today we're going to be talking about a few things such as the internet and sales tax and hiring practices and questions and what's legal and how do you handle and manage your business and how do you handle things that happen with your contractors. Okay, David, let's get to it. So, one of the issues that comes up, everyone knows that it's so convenient to shop online. The brick and mortar stores have been struggling for a long time. Now almost everyone likes to shop online. It's convenient. These become powerhouses. It's competitive. It's convenient. Sometimes there's no shipping. And now the issue is adding insult to injury. We understand that there's an issue about sales tax. Sometimes they charge. Sometimes they don't. In thinking about the big controversy, it's obviously been issue enough that it's heading to the U.S. Supreme Court. Supposedly by June they're going to decide. So this research, South Dakota versus Wayfair, South Dakota is seeking to overturn a decision which says retailers only have to collect tax in the states where they have a physical presence. Now, Amazon's having more of a physical presence, as we understand, but other states and local governments say that they've been cheated out of billions of dollars because of this rule. Comment?
Well, there's a lot of issues going on there, and typically the state was allowed to charge a sales tax for any transaction that happened within the state. So the question would really become, can a state charge a sales tax for a transaction that happens on the internet? And if it happens on the internet, where does it happen? And what state's allowed to charge the tax? And who collects the tax? And how does the tax get paid? So it has been, from the beginning, sort of the wild, wild west on the internet. And there were no procedures or anything for companies to collect sales tax. And that has begun to change, and some of them do collect tax on for the state in which the order is placed. So if you're in Rhode Island and you place the order, there might be a sales tax that's added on and sent to the state. But it's really a case-by-case basis and a company-by-company basis right now, and that's part of what that case in the Supreme Court may help decide one way or the other.
It was kind of interesting to read that, for example, if I order something online through Amazon, Amazon may have trouble fulfilling it. I know that there's an Amazon location in Massachusetts that's doing fulfillment, but wasn't it interesting to see that Amazon delivery, which came to Rhode Island, came from Walmart. So they contracted with Walmart, which is definitely in this state, every state, just about, I guess. And the issue about sales tax, I understand how the states don't want to be denied or deprived a little money grab for sales tax.
Sure. And so, for instance, in Rhode Island, we have a use tax. So you're supposed to collect and pay to the state your own, what would be a sales tax otherwise. And there was a push at one time to get everybody to report, what did you buy in Massachusetts? What did you buy in other places online? And then send us the 7% or whatever it is tax that you should have paid for sales tax, and do it voluntarily, or we'll just give you a percentage and you can pay that. And so there were a lot of issues with that and a lot of problems. So I think it might make more sense to just figure out if there are going to be sales tax online, and is it where the purchaser is, and collect it that way and send it in. And if it's a company that's big enough like Amazon, they should figure out a way to do that.
And since recently it was tax day, or it is still tax collection day, when your accountant happens to say to you, to your point about the sales and use, so you might have bought things in Dakota, California, and whatever. Should we just give a blanket percentage to the state to avoid all problems? What would your thoughts be
Yeah,
about
well,
that?
that was part of the theory
Yes.
behind some of the rules that they put in place. And, you know, if you do most of your buying in Rhode Island and you don't use the internet, in other words, you're like me, because I'm a little leery still of
Yes.
buying things on the internet. And, you know, it's really changed, and I know I shouldn't be, and my wife isn't as much as I am, but I like to see it. I like to touch it. I like to go to the store. I like to get out of the house. I like to do all those things. So I wouldn't pay for me that, like, well, here's a flat number or percentage you can, because I know I don't buy a lot of things that aren't bought in Rhode Island. But if you're an internet shopper and you're in other states and you're doing all of that, you know, it may be a way to do it and have just comfort knowing you've paid what you're supposed to pay.
Sounds like a reasonable way. And you are interesting that you're probably one of the few who do not buy just about everything, who does
I'm
not.
one of the few left.
So we had several questions from people who are applying for jobs. Theoretically, the job market's getting better. So for those who are applying for a job, David, is it legal for a job application to include questions about whether or not someone's been charged or convicted of a crime? I thought I understood this, but comment on this, David?
Well, it's interesting what you're allowed to ask and not ask, and charged versus convicted, I think, is a big issue.
Yes.
Because anyone can get charged with a crime. Have you been convicted of a crime? And many companies will do their own criminal background check now anyway.
Yes.
So it's, you know, it's an area of the law that's sort of always been of interest to me, because I don't think that they should be allowed to ask, were you charged with a crime? Because, like I said, anyone can be charged. The conviction of the crime is a legitimate area, especially in certain types of jobs. And if there's a job where there's security clearance needed, clearly they can ask those things. If there's a job where there's a certain amount of trust that's needed, you're working with expensive materials and they're afraid about stealing, and you've got a history of being convicted of stealing, that's relevant. So I kind of think it's sort of, I don't want to say case by case, because it's not, but it really is maybe an industry type of related issue that really needs to be answered. And I can think in today's day and age, you can rest assured that there can be criminal background check done anyway, and so you may as well, you know, be upfront and honest about it and explain what the situation is.
And how would you counsel someone who is applying for a job, say they've used you before as their defense attorney? Okay, David, I've done the crime, paid that penalty. Now I want to get on with my life. I have to interview. What should I say? Should I ignore it? How do you tell your clients to handle that?
If I represented them, of course, then they were never convicted.
Of course
right?
not.
It goes without saying.
Point well taken.
So if it's whether or not they've been convicted of a crime, usually they'll call me and ask me, well, did I plead to this? Did I do that? Is that a conviction? No, that's not a conviction. So you have not been convicted of a crime.
Good point to remember, too.
Right. But if the question is, have I been charged with a crime, I usually would tell someone, just be upfront with something and explain the situation. And usually that's the best policy. Sometimes it may not be, but for the most part, I would say in general, you just say, no, I have not been convicted of a crime, but would feel free to discuss this in person if you have any questions about it.
And what about a young person who has had a few encounters with the law? DUI, or perhaps they were pot smoking in a city where it was legal, drove over the state line, it wasn't,
Right.
and ended up being stopped for an unrelated and then discovered to have had pot in their possession. What do you say to someone who later on is being interviewed? Should they
Well, certainly,
fess up?
if it was as a juvenile,
Yes.
those records are supposed to be confidential. They're not supposed to follow you the rest of your life. And again, of course, it depends on what type of job you're applying for. If you
Yes.
need super top level security clearance, they're going to find even a juvenile record. So just, you're going to have to deal with that. But if it's a juvenile record, it's, for the most part, not supposed to be discoverable and not something that follows you, and you shouldn't have to deal with that. Now, if you were a young person of an adult age and there's something on your record, if it can be expunged, I would get it expunged first. And there's rules on expungement and what you can expunge and when you can do that and so forth. So check with a lawyer if you have something on your record that you think should be expunged and have it taken off.
And that would mostly apply to someone who wants to have an upper-level management or position or security clearance, et cetera.
Right.
Pertains to them mostly.
Right.
Let's talk about money and hiring. So compensation is always a hot topic about equal pay and equal work. How about someone's interviewing you? So David, what's your salary? Is that a legal question for an interviewer to ask these days? This was an interesting thing to come across.
Is the question, what's your salary now? Or is the question, what are your salary requirements? What are you looking
So
to
the
make?
first level that was posed, what's your salary now? The comments that came along with that was, well, if I tell them that I had a very low salary, that gives that would-be employer an opportunity to lowball it. The other side of it, and there is, I guess, the other side of that, which is I had a very high salary, and if I tell them, if I divulge that, then they're going to think perhaps I am ineligible because they wouldn't be able to offer a similar salary or compensation.
So
what do you say to that?
My answer to that is deflect. And here's what I
Deflect.
mean by that.
Okay.
I'm applying for a job with you. I'm making below market salary. I'm being paid, make up a number, for a very good job. I'm only making 35. I should be making 50 or 60. So you ask me what I'm making. I'm going to say to you, well, this is what I would like to make if I came to work for you. So,
Should you say that number first, or should you wait for the employer?
well, if
how
they're
does that work?
asking me what I'm making,
Yes.
and I don't want them to know
Yes.
what I'm making, either because it's too high or too low, I'm deflecting or changing or moving the conversation to what I want you to know. And so don't waste your time or my time if you can't pay me at least 65, because that's what I'm going to need to leave my current job.
Good to know. And interestingly, this came up because apparently there are other states that are fighting this, essentially or initially through the Chamber of Commerce. They're saying that they are going to have a salary history prohibition. So in other words, you can't ask what were you making in your last job or your most recent job or whatever. So I guess Philadelphia, New York, and Massachusetts are looking to bar the employer from asking such questions. Something
Yeah.
interesting to watch.
Yeah, and like I said, what I'm making right now is really somewhat irrelevant to our conversation anyway. Do you want to hire me? Because I really want to work for you. And
Good to know.
if my salary's out of the range for you, we should just know that up front.
Good way to handle that. On a more personal level, we understand that sanctuary states have been in the news, sanctuary cities have been in the news. Providence itself has had its challenges. So is it legal, not for a city, but for a church or synagogue or any house of worship to provide sanctuary for undocumented citizens? Are they off limits?
I would say no. Under our Constitution, you have separation of church and
Okay.
state. The church is not an arm of the state. A church
Right.
or a synagogue has a right to help all people, and sort of like it says on the sign on the Statue of Liberty in Ellis Island, would give us your poor, your whatever,
Your weak.
your weak, your mass, whatever. Churches can take that position, and the church does not have an obligation to run a background check or report you to ICE or whatever else might be the situation if they're just there to serve and help.
So apparently, as far back as the 1980s, there was a church that was well known in Tucson, Arizona, that helped launch the idea of a sanctuary church. And somewhere recently there were 400, now there are something like 800 nationwide that are trying to provide some physical haven, which is a very interesting thing, different from the cities who say that they want to be sanctuary cities and still want access to federal funds, and
Right.
we get into the constitutional
And
issues.
I know this is sort of around the anniversary of that whole Branch Davidian issue, which is a totally different type of situation. We're not talking about a church that is taking people in and sort of fighting the federal government on
Right.
an issue. We're talking about providing help and services to people who need it.
Yes, that was the distinction that they made too. Good point. Along the lines of cyber attack In other words, in many cases, we are hearing just about every online entity can be victimized. So you as a lawyer, you have attorney-client privileges, you have a reasonable way of protecting your clients' files. If they were all paper once upon a time, they were in a filing cabinet. I assume they were locked. I assume that the people who were touching your faxes, they're still part of the attorney-client privilege. Well, now things are done online. It has certainly become a wild, wild west. What can you do, and what's reasonable for your clients to expect? You're only human. You could be hacked too.
Right.
What happens, David?
So you sort of touch on two different areas. One area is securing information.
Yes.
And the other one with attorney-client privilege sort of is an issue that's been raised more topically recently with perhaps, I'll call it FBI search warrants being
Yes.
executed on attorneys. And so, of course, the first issue is more of a cybersecurity issue, and we, as in my firm, for example, have a tech company that helps us secure all of our information and provides through our, either if we had a network or a cloud, I won't say which, but either one is protected with all sorts of software, malware, other types of protections that can be provided. But we're not an insurer of that. They're not an insurer of that. They just provide the best protection you can. And you try to hope that whatever folks are out there that are trying to defeat those things can't get through. But that's something you just have to hope that your tech companies can help you with.
Of course, there are such sophisticated hacking techniques these days that the likes of which we had not known before. And you and I assume accountants and doctors too have such a trove of information, the social security number. And if you are building a case, you have things that go back and forth through your email. That's of course one of the least secure ways of dealing with things. But I know the one thing that they say is make sure that you don't, your lawyers and accountants shouldn't be having the free email accounts because those are the most easily hacked. But do you tell your clients that you will only use certain ways of communicating? Please don't send me your social security number over the email. How do you work with that?
So we do not ask for any private information from our clients back and forth through emails. That's something we don't do. Now, there can be things that are shared that has some private information, usually not social security numbers, but as lawyers now, we electronically file our documents with the court. So I don't know what protections there are. I'm sure there are lots of them. And again, there's not a lot of private information in there. There is some. You're going to have people's names and dates of births on some things and that type of thing. But I can't think of any documents we file that would have social security numbers in them. But again, that's the way we have to do things. That's the way business is done today, electronic filing. And it's done through portals with the court, and I'm sure the court has technology companies that are designed to protect all that information. And of course, we're hoping that our information is protected by our technology companies as well.
And while you're handling cases, whether it's a bankruptcy or a divorce or whatever kind of proceeding, do you now have an added layer of discussion with your clients about, since we're in this procedure, please don't post your activities, whatever, online and through emails that can be acquired or lifted or hacked?
It is an area that is ripe for discovery. Family court, of course. If you have situations where your client is separated and is still married and they're online or Facebook or wherever with all different things posted about them, doing things they shouldn't be doing perhaps, and it's a custody battle, you can rest assured that the other attorney is going to come in with printouts of all of those things that you did or didn't do and shouldn't have done. Same thing with personal injury cases, or workers' compensation cases where you're saying, you know, I can't do this, that, or the other thing. In the old days, 5 years ago, no, only kidding, longer back, insurance companies would hire private detectives to follow you around. And I remember one case that my office was involved with where, I guess, unbeknownst to us, our client had a second job. His first job was maybe working for a trucking company, say. The second job was he delivered balloonograms. And so the insurance company adjuster hired him to come in with a ballonogram, and there he is on video delivering the balloonograms and dancing and all sorts of things. And I kind of said, well, yeah, sure, he can lift a helium balloon and dance maybe, but he can't lift those 20-pound boxes at the trucking company. But of course, that's how they would do their discovery on what you could or couldn't do then. Now, a lot of times, all they have to do is look online and see what you've posted, pictures of you lifting up your bride at a wedding. Just remember, they're looking.
And that's not a work issue, that's a personal issue, but that still becomes
It
part of the
can
discovery?
become an issue if you say, I can't do that, and then they have pictures of you doing that. That can be an issue.
And Snapchat isn't good enough. I mean, the thing that lasts 3 seconds and it's gone, it's really not.
Yeah, you're talking technology. I
Beware.
get one of my daughters here to answer that question.
Beware those things. And it's interesting, like, I'm sure, and even an email, if someone is having a conversation back and forth with you about the case, could that ever be accessed? Or is that attorney-client privilege?
That should be attorney-client privilege. You're communicating about strategy and advice and how we're going to deal with the case. So it's not different to me than any other correspondence.
And even if they happen to talk about the fact that they might have done the thing of which...
Whatever you see, first of all, we wouldn't be doing that by email.
You wouldn't.
But if an attorney did have something like that by email with the client, and it's directly with the attorney, it should be protected. If it's some other correspondence that is about a case but not necessarily with a client, that might not be protected by attorney-client privilege because it's not advice, strategy, or something relating directly to the case that you're discussing with your client. It's the correspondence, conversation, discussions with the client that would be protected.
Say you take the train, David, and you have your laptop computer with you. You want to have access to Wi-Fi. Do you have to be more careful than, well, everyone should be careful. Do you have to be more careful about not using the train or the bus's Wi-Fi, which is an open and theoretically easily hacked property? Do you not do any work on a train when you're commuting for that reason?
I don't commute.
Okay.
And I don't go on a train, and I don't have a laptop.
Okay.
So I do all my work at my office or from home, because I can do it from home.
Yes.
But I think the answer is, of course, you need to be careful, but I don't know what real precautions you can take if you need to do work. For example, a lot of attorneys bring their laptops to court and they log into the Wi-Fi system that the court has, and they do work and file documents and do a lot of good work right from court. I think they have to operate carefully, but I don't know what they personally can do. Again, it's a tech question beyond my pay grade.
Okay, it's fair enough. And one other question, considering there's been a lot of storm damage, people have to have it repaired. So the tree falls on, your tree falls on your house, you need to have it repaired. So you hire a contractor and you're having problems with them. For example, you hired the contractor to fix the roof, they're supposed to show up, they don't. What recourse do you have? Or they do the work, you paid them, they did shoddy work, it rains, and now you have leaks again.
Yeah.
Do you have a court case? What do you do?
Yeah, so first of all, it's always a good idea to get as much of what's going to be done by somebody in writing in the form of a contract so that there's no question what the scope of the work is to be done. Then, of course, when it doesn't either get done timely, get done correctly, there's a lot of different ways of having some recourse. If you've hired someone who is a licensed contractor with the state, you can file a complaint with the Board of Contractors and explain. This is one of those things where you'll always say to me, David, you always say have documentation, get documentation. You want to have your documentation, your contract. This is what they were supposed to do. This is when they were supposed to do it. this is what happened at this point, this point, this point, and this is what never got done. So you can file that complaint, and the state will take some action to help get that situation resolved. If that doesn't work, of course, you can file a suit in Superior Court or District Court, depending on the amount involved.
So in that case, you would need a lawyer once you're getting involved with that.
Yeah.
Maybe it's small claims court if it's a minor amount under
$2,500.
$2,500. But if you'd like to avoid that from happening in the first place, do you actually have more leverage if you debate or discuss with that contractor first the payment structure? Do you give him money before he starts? That would be nice. He might not even show up with the lumber to repair or something. How do you deal with that?
So, contract, written. This is what I'm going to do. This is the payment schedule. This is what you're paying me first. $1,500 deposit before I do the work so I can order the materials. Okay, fine. I will do that. But I would like a copy of the order to show that you've actually placed the order for the things that I need.
Before I pay you?
No,
You do
because
pay them first, okay.
they may have to use that money as a deposit for that. And if they don't have to use that money for a deposit, I don't think that they're going to want to go out necessarily and order it until they have the contract and the first payment.
Okay.
But you try to keep that first payment to as low a number as reasonable. But if there's materials that are expensive and need to be ordered, fine. But show me that you ordered it. And I want to know that you ordered it within, I'm going to pay you by check perhaps. I want to know within 5 days. No, yet I'm going to pay you by credit card if they accept
That's
credit cards.
That's what I was going to ask. That's a good
Yeah.
question. Good point.
And I want it done, and I want the order, and I want you to give me that back within 2 days, 3 days, whatever it is. Then if you don't get that back and it's by credit card, you can dispute the charge with the credit card company and say, they didn't do what they were supposed to do. I don't trust them. I want out.
And if you can, is it a better idea to negotiate that last payment when the job is finished rather than before it?
As little as you can up front, as much as you can at the end, and to your satisfaction. And sometimes there are certain inspections that need to be done depending on what the work is. Maybe you need the building inspector or zoning inspector to come by to take a look at the work, electrical inspector if there's electrical work. I'll pay you I'll pay you the next one upon this inspection passing. I'll pay you the next one upon the last inspection passing, and then I'll pay you the rest at the end if it's like a new construction, I get my certificate of occupancy.
Good plan to do that. If you have things that are insurance-based, there's a deductible, then suddenly your premium goes up, your deductible goes up. Is it fair, is it legal?
So, it depends on what type of claim and how many claims.
Storm damage.
Storm damage, it should not affect, you've had one claim, you've been with your company for 20 years, it shouldn't affect your premium or your deductible.
And of course, you could always shop around if you needed to.
And then you can do that.
Thank you. We hope that this has been helpful to you. We appreciate your questions that you've submitted. We thank you for staying tuned to The Law Matters because, as we say, the law matters to you.